Now I would like to ask Anna Kaloris to join our discussion. Anna represents Office of the Prosecutor at the International Criminal Court. In Ukraine, it's like the International Criminal Court is not so much well known as the Hague Tribunal. In the Hague, nobody knows what does it mean, but actually there is a mixture of terminology. I really remember many, many years ago, I was just an activist at Amnesty International, and at that time, as a big international organization, we were advocating for the ratification of the Rome Statute. And for the people who belong to this human rights world, like this diplomatic meeting in the Rome and adoption of this statute was like something really huge, just to end impunity for the worst crimes. Of course, like at that period of time, I would never even imagine that the Rome Statute could be operational and could be actually useful to make legal assessment of the events which happened in my country. I would like to ask you first of all, Ukraine has not ratified the Rome Statute, but you are on a certain stage of the work with the situation in Ukraine. So do you have sufficient support, sufficient collaboration there the jurisdiction came from, and what are the main sources of information, what we can expect from the work which is being conducted already by your office and by the ICC in general? Please.
Thank you, Roman. First of all, thank you for inviting me. I'm very happy to be here. Indeed, as you mentioned, there is often some confusion between the courts in The Hague, and perhaps the location has something to do with the confusion. But there is quite a distinct difference between the ICJ, the International Court of Justice, and the International Criminal Court, which I work for, and I work for the Office of the Prosecutor at the International Criminal Court. So, as you said, the ICC is a much younger institution, in fact, than the ICJ. The main distinction between the jurisdictions of the ICJ and the ICC is the ICJ is the judicial arm of the United Nations. So it deals with disputes between states. The ICC that I work for is an independent court that is established by treaty, by the Rome Treaty. That the court, as I said, is much younger. You talked about the establishment of the court and how you were involved in it. Sorry, is this not? Is it? Is that okay? It's better? I'll speak a bit closer. Sorry. I hope everyone caught what I already said. So as I mentioned, the ICC is an independent court. So it's set up by the Rome Statute, and the Rome Statute is more than just the court. The Rome Statute is actually a system of states. So the ICC is a state that is concerned with individual criminal responsibility. That is not disputes between states. We conduct independent assessments, and if we deem that an investigation is warranted, we open an investigation into a situation. Our jurisdiction is also a bit different from the ICJ in that we are a court of last resort, well, the ICJ is also actually, but that means that primary jurisdiction even for the crimes that are within our statute still remains with national jurisdictions. And the ICC will only investigate a situation and prosecute a case if the national jurisdictions are not effectively investigating and prosecuting them. So it is complementary to, and this is what the principle we call complementarity, it's complementary to national jurisdictions. So to get to the situation of Ukraine briefly, as you mentioned, we are conducting what we call a preliminary examination of the situation in Ukraine. What is a preliminary examination? It's a term that may not be familiar to some people, and it's more or less a unique process that's set out in the Rome Statute, and the responsibility for conducting a preliminary examination is given to the Office of the Prosecutor. So it is, in simple terms, an assessment of whether the Rome Statute criteria for opening an investigation into a situation are met, if there is a reasonable basis to believe that an investigation should be opened into a situation. So it's not an investigation. Our examination of the situation in Ukraine is not an investigation at this stage, and there is some confusion about that sometimes. It is an assessment of the Rome Statute criteria. What are those criteria? So the criteria are jurisdiction, which, as you know, our jurisdiction, territorial jurisdiction for Ukraine is based upon two ad hoc acceptances of jurisdiction that were made by Ukraine, because Ukraine is not a state party to the ICC, but the statute does allow for states to accept jurisdiction of the court on an ad hoc basis. So the jurisdiction is one aspect of the preliminary examination, and the other side of jurisdiction is subject matter. So we need to examine whether crimes within the jurisdiction of the court, crimes under the Rome Statute, which are exclusively war crimes, crimes against humanity, and genocide, is there a reasonable basis to believe that such crimes have been committed within the situation we're examining? So this is the stage, in fact, that we're currently at with Ukraine. And the first major step in examining the jurisdiction, the subject matter jurisdiction of the court, was for us to determine the legal framework in accordance with the Rome Statute. And we've made some headway in our analysis in doing that. And we made our preliminary findings in that respect public last year. So we found that the law of international armed conflict applies in Crimea, in as much as there's an ongoing occupation on the territory of Crimea, and that in eastern Ukraine, the situation also amounts to an armed conflict of a non-international nature. In parallel, there is, we found in our preliminary analysis, an international conflict on the basis of direct engagement between Ukrainian armed forces and Russian armed forces. So that we made public last year, and the reason we needed to make that legal assessment of the factual situation in Crimea and eastern Ukraine was so that we could determine which parts of the Rome Statute, which articles of the Rome Statute are applicable to the situation. So try not to get too technical about it, the specific war crimes are different depending on whether there is a non-international or an international armed conflict. These are principles of international law that are sort of not only unique to the Rome Statute, but also exist in the Geneva Conventions. So we are now examining the events and the alleged acts that have occurred in eastern Ukraine and in Crimea since 2014. And that is quite a complex analysis. As you can imagine, there's a lot of information. We receive information from a variety of sources. I think that was one of your questions, Roman. I hope I'm answering them all. The information we use in our analysis comes from many sources, some of them publicly available, and some of it received. Anybody can submit information to the ICC, in fact, and we can request information also from states, international organizations, other relevant actors, if we deem it necessary. And that information we use and we evaluate closely for credibility, reliability, and we seek to corroborate any allegations, basically. So this is a complex situation that we're looking at with Ukraine, both in terms of the legal framework and in terms of the events that we're having to analyze. The next step after this jurisdiction assessment that we're currently in, so if we do find that there is a reasonable basis to believe that crimes within the court's jurisdiction have been committed in Ukraine, then the next step for us to do will be to assess the admissibility of potential cases. So while we're assessing the alleged crimes, we also need to identify what potential cases the ICC might investigate. And on the basis of the potential cases we identify, we conduct an assessment of whether those alleged crimes are already being investigated or prosecuted by a national jurisdiction. So that is where this aspect of complementarity comes into play in the jurisdiction of the court. So those potential cases would not be admissible if they are already being effectively investigated and prosecuted by national jurisdictions. The other aspect of the admissibility phase is gravity. So we look at the complementarity and gravity during that phase. We're not there yet, but that's the next stage of the assessment. And the final aspect of the preliminary examination phase is an examination of the interests of justice.